Jono Naylor.
Thank you, Mr Speaker. And I just want to echo the sentiments from the former Speaker. It's certainly a pleasure to sit on that Justice and Electoral Committee, and I'll touch on that a little bit further as I go through my speech. Mr Speaker, I want to start by just reflecting a little bit on what a good judicial system looks like. And of course, first and foremost, it has to be just, and justice needs to be done, it needs to be seen to be done, and it needs to ensure that it brings perpetrators who are guilty to have an appropriate either consequence for their actions. It needs to be timely, and it needs to happen in an appropriate time to ensure that justice is being done. But I think the third phase of it, which to me is probably most critical, is that our judicial system must not re-victimise our victims. Now, this bill, I think, just really does enhance our judicial system in a number of ways. Particularly, there's some aspects of it which will improve timeliness, and that's been expressed already through the Minister's opening remarks, so I won't dwell too much on that. But I do want to focus particularly on the aspects of what I think is really one of the critical points, as I said, about the judicial system, that we do not re-victimise victims of crime, and to a certain degree that we don't victimise witnesses of crime either, because often they witnesses the untalked about victims when crime is concerned, particularly when somebody has witnessed something that is particularly distressing. They have become sort of by association victims, even though they may not have had the crime specifically performed against them. And Mr Speaker, this is in line with a huge amount of work that's already been done by this government through other legislation, through the Victims' Rights Amendment Bill, which was being dealt with, through, and I've forgotten the name of the legislation, but that provides for an offenders levy to be levied to, so that offenders are therefore having to pay to provide better services for victims and otherwise. And as previous speakers have alluded to, the Harmful Digital Communications Bill, and is showing again, I guess, that this government is committed to ensuring that victims are being looked after, that victims are at the forefront of our mind when we're thinking about the judicial system, and we're ensuring that they are receiving the best care and the best best processes to ensure that they can come through their experiences in the best possible shape. And this is where I believe this Evidence Amendment Bill really does come into its own. And I particularly want to focus on this point about how evidence is gathered from victims, particularly young victims, through alternative means other than putting people in a witness box. And I particularly like the fact that now this is going to be a presumptive position, that first and foremost it's going to be assumed that a child will give evidence in this way, instead of an application having to be made and a Crown prosecutor or otherwise being unsure of what the outcome of that application would be. And Mr Speaker, if I can just divert slightly and tell a little bit of a story that I think is relevant to the situation from my own past experience. I come from a background where I was working in social services, and I've had to deal with young people in all sorts of difficult situations, but a particular situation came to mind where a young teenager confided in me that she had experienced a gang rape, and it was particularly traumatic for her to have to disclose that to me, and as you can well imagine, not particularly pleasant for me then to have to deal with. One of the tricky things that I faced in dealing with that situation was having to explain to this young woman that in order to bring justice to the perpetrators of that crime, she was going to not only have to tell that story again to the police, but potentially have to tell that story again and possibly again in court. And while she was keen to see the perpetrators brought to justice, that was a big hurdle for her. That was not something that I particularly wanted to have to do. And there was good law in place. As a professional who was the first person to hear that, I, of course, was interviewed by the police, of course, because there is aspects whereby that evidence can be admitted as well. But under this legislation, should it pass, for a professional working with somebody like that who would make such a disclosure, it provides a much better avenue to take that person forward in their journey of dealing with the issue and recovering, but also bringing those perpetrators to account. Because, Mr. Speaker, it would be great to then be able to acknowledge to that victim that actually it was assumed that they would not have to stand in front of the court and retell their story, that it would be able to be done in an environment that was more suited to them, and that they would be able to have a support person with them while they did that. And I think the point that's been raised by Mr. Henare over there about the nature of that support person is a really important one, and it's probably something that we are going to need to think about, because but say in the situation that I'd found myself in, it would be good to have a professional person who perhaps had been supporting this person through what they were facing, perhaps might be the support person in a case like that. But we do need to ensure that actually there isn't an opportunity for a victim or a witness, as I said earlier, to be sort of put in a compromised position because of the nature of the support person that is around them. And that's clearly something that we're going to have to think about. And so, Mr. Speaker, I really do look forward to this legislation coming to the Justice and Electoral Select Committee. As I said before, it's a very good committee, ably chaired by Jackie Dean, who we've heard from this evening, who is possibly, one of the better, if not the best, Select Committee chair in the House. That's 4 times I've said it now, Jackie. I've only got to say it one more time. It's controversial, I know, and I'm going to upset a whole lot of other committee chairs out there, but a deal's a deal. I said I'd say it publicly, and I will. Anyway, but all jokes aside, Mr. Speaker, this is a very, very serious piece of legislation, and it is one that I think perhaps through the Select Committee process, maybe there is some things that we can examine and look at that may help tweak it a little bit. But the basic premise of what is in here, what it is trying to achieve, I believe, is exactly where we need to be moving as a nation. It's exactly where this government is committed to doing, to ensuring that victims and witnesses of crimes are being dealt with in the most appropriate way, that we are doing so without causing them any more suffering than what they have already been through, any more than is absolutely necessary. And so, Mr. Speaker, I look forward to seeing the passage of this bill through this Parliament and look forward to getting to the point where we arrive at the 3rd reading, we can give it royal assent, and our speakers, and that our victims will be able to, I guess, really have confidence in our system. I think ultimately that's really what it's about. It's about us as lawmakers in New Zealand being able to give the public of New Zealand even more confidence in our judicial system. And by allowing victims of crime, particularly young children, this presumption that their evidence will be gathered in this way, that we're going to be ensuring that they are looked after, Mr. Speaker, I believe will really deliver a positive outcome for New Zealand. And so, Mr. Speaker, as I said, looking forward to this coming through the Select Committee, looking forward to its passage through the House, and certainly look forward to this being passed into law. Thank you.